Morning, everyone. I'm Brian Beamish, Ontario's Information and Privacy Commissioner. Welcome to the fifth installment of our online webinar series. The purpose of this series is to engage stakeholders like you in important access and privacy issues facing the province's health and public sectors. As you know, today's focus will be on video surveillance, and we will be looking specifically at issues around instituting a video surveillance program in your institution, what you should consider before and after implementing such a program. Over the next hour, we'll give you guidance on how to use video surveillance in a way that respects and protects individual privacy and helps you comply with the province's access and information laws. We will start with a pre-recorded 20-minute presentation. After that recording is over, I'll be joined by Assistant Commissioner David Goodis and Senior Policy Advisor Jennifer Rees-Jones to answer questions that you have. I should say that after this presentation is done, the full webinar and other resources will be available on our website. You should feel free to submit your questions on the on-screen chat forum that you'll see during the presentation. We've had approximately 600 people sign up, so you should get your questions in early. Your questions will be anonymous. They won't identify who has sent them in when we read them, and other participants won't see them. And we'll do our best to get to as many as we can during the Q&A session today. We probably won't get to all questions, but we will be reviewing the questions that were sent in following the webinar and look towards preparing a FAQ so that we get to everyone's issues. So with that as an introduction, we will now begin the presentation, and we'll speak to you in approximately 20 minutes.
Hello and welcome to the IPC's webinar on the do's and don'ts of video surveillance. As part of our mandate, the IPC provides guidance on Ontario's public sector access and privacy legislation. These laws are the Freedom of Information and Protection of Privacy Act and the Municipal Freedom of Information and Protection of Privacy Act. Today we will be discussing your institution's obligations under these acts when it comes to video surveillance. We will also be sharing some best practices. Video surveillance programs are mainly used for public safety reasons, to detect illegal activity, and to assist in any follow-up investigations. They may also act as a deterrent. While video surveillance may enhance public safety, it also poses risks to the privacy of individuals whose personal information may be collected, used, and disclosed. Under Ontario's privacy laws, you should only resort to video surveillance if it can be justified. It is also critical to remember that individuals have a right to go about their daily lives free of widespread surveillance, including in public spaces. The feeling of being watched or monitored by the continuous gaze of video surveillance may have a chilling effect on law-abiding individuals, causing them to alter their behavior and limit the expression of their rights. This right to be free from constant surveillance, even in a public space, has been consistently acknowledged by our courts, including the Supreme Court of Canada. With the many privacy risks arising from the potential for excessive use of video surveillance, special care must be taken when considering whether and how to use this technology. How can your institution ensure that its video surveillance program complies with Ontario's access and privacy laws and protects the privacy rights of Ontarians? When considering the use of video surveillance, you must first address whether the system will involve the collection of personal information. This will likely be the case in that most video surveillance systems collect personal information by capturing images of identifiable individuals. The next step is to determine whether your institution has the legal authority to collect personal information. In Ontario, institutions must meet at least one of three conditions in order to have this authority. The collection must be expressly authorized by statute, used for the purposes of law enforcement, or necessary to the proper administration of a lawfully authorized activity. Let's take a closer look at how each of these conditions may be met. The first condition speaks for itself. A statutory authority to collect personal information must be expressly authorized in specific terms within a law or regulation for this condition to apply. Therefore, if a law or regulation gives your institution the express authority to collect personal information through the use of video surveillance, you are expressly authorized to do so. This type of authorization is rare in Ontario. It is important to note, however, that an authority that is stated in non-specific terms would not be enough to be considered expressly authorized by statute. The second condition only applies to your institution if it has a clear law enforcement mandate. You cannot justify the collection of personal information by simply claiming to have a mere interest in policing or law enforcement investigations. Even if your institution has a clear law enforcement mandate, say you are a police service or a transit authority with special constable services, this is not an unconditional authority. Law enforcement officials are only authorized to collect personal information in cases where the collection furthers actual law enforcement purposes. For example, law enforcement officials may use video surveillance to monitor crowded areas linked to excessive drinking, violence, or other illegal activity. Which brings us to the third condition for the lawful collection of personal information, necessary to the proper administration of a lawfully authorized activity. To satisfy this condition, your institution must demonstrate two things. First, that the activity for which you collected personal information is lawfully authorized under a statute, regulation, bylaw, policy, or order. And second, that the collection of personal information is necessary to that lawfully authorized activity. Let's look at each of these in greater detail. In the case of video surveillance, a lawfully authorized activity will typically relate to the safe and secure operation of your buildings, facilities, or public space. For example, school boards are lawfully authorized to operate schools. As such, they may be able to justify the use of video surveillance on school properties as a way to ensure the safety of students and teachers. Likewise, a public transit authority is authorized to operate public transportation services and may be justified in using video surveillance cameras on buses and subway systems to ensure the safety of passengers and transit staff. The other critical element in determining whether you have the legal authority to collect personal information requires that the collection be necessary to the proper administration of that activity. Necessary here means more than merely helpful. If your institution collects personal information that is only helpful to the activity, it would not meet the necessary standard. How can your institution meet this standard? You will need to consider whether using video surveillance is necessary, as well as the sensitivity and amount of the personal information to be collected. In assessing whether you need video surveillance, first consider whether the underlying problem or concern you would like to address is real, substantial, and pressing. There should be specific incidents of crime or significant safety concerns that you need to address. A minor offense, such as littering, would generally not be considered a substantial or pressing problem that would call for the use of video surveillance. Second, determine if there are other, less intrusive and effective ways your institution can address the problem apart from video surveillance. For example, if a dimly lit area of a community center's parking lot is the site of ongoing vandalism, before it considers using video surveillance, the municipality should first evaluate the effectiveness of less intrusive alternatives, such as increased lighting in that area. Third, consider whether the benefits of video surveillance substantially outweigh the reduction in privacy. Institutions should also bear in mind the sensitivity of personal information they collect by means of video surveillance. The greater the sensitivity, the harder it is to justify video surveillance, even when it comes with clear benefits. In this regard, look at the nature of the space under surveillance and the closeness of the surveillance. Some spaces are considered to be more sensitive than others. For example, individuals have a high expectation of privacy in areas such as public washrooms. The sensitivity of these spaces is considered to be higher than that of open-air public spaces, such as public roads, parks, and squares, where individuals generally have a lower expectation of privacy. Still, even in a space in which there is a relatively lower expectation of privacy, sensitive personal information may be at issue. This is especially true if your video surveillance technology can zoom in, for example, on individuals sharing an intimate moment sitting on a park bench. Suddenly, the sensitivity of that space and the personal information collected in it would increase. Finally, consider the amount of personal information that you collect. Your institution must limit the amount of personal information it collects and retains through the use of video surveillance. One way to do this is by ensuring that the video camera does not capture information from adjacent buildings or properties. Instead, video cameras should only be installed in and directed at areas where the underlying problem or concern is present. Another example is to avoid the collection of audio in your surveillance program. In short, when it comes to your video surveillance program, a few things to remember are: do not deploy cameras except in relation to real, substantial, and pressing concerns. Ensure that cameras are not in areas where individuals have a higher expectation of privacy. And do not collect more personal information than you need. For example, disable or minimize any pan and zoom functions to avoid the overcollection of personal information. In Ontario, public institutions must notify individuals about the collection of their personal information. To provide effective notice in the case of video surveillance, you should prominently display signs with a clear, language-neutral graphic depicting the use of video surveillance within the monitored areas. These signs, or some other form of notice, including a notice on your institution's website, must describe the legal authority for the collection, the principal purpose or purposes for which you intend to use the personal information, and the title, business address, and telephone number of a primary contact in case there are any questions. Providing effective notice is contextual. Institutions should consider the audience and tailor the approach. For example, if the surveillance takes place in an area with a high concentration of visually impaired individuals, institutions should consider providing notice in an alternative form. An important aspect of managing a video surveillance program involves protecting personal information from misuse. Ontario's privacy laws restrict how personal information may be used once it has been collected. As a general rule, you should not use the information collected from video surveillance unless it is used for a purpose consistent with the original purpose of the surveillance program. In other words, you are generally not permitted to use video footage for other unrelated purposes. Let's look at a school to further illustrate this point. A security camera set up to monitor the entrance to a school to address security concerns will typically collect more information about the movements and activities of law-abiding individuals than information relating to a security incident. To avoid the risk of function creep, the school should not use the personal information collected by the security camera to monitor student attendance, for example, but it may use it in relation to a security incident. There are rules for when and in what situations your institution can disclose personal information captured by your video surveillance system, including disclosures to law enforcement agencies. Generally speaking, you should only disclose personal information to a law enforcement agency when required by law, such as in response to a court order. However, institutions have discretion to disclose personal information in other situations, such as where disclosure is made to aid an investigation and for health or safety reasons. For example, you may consider disclosing footage to a law enforcement agency on your own initiative where you have reasonable grounds to believe that an offense has occurred on your premises. Let's say you learn of an alleged assault on your property in an area monitored by video surveillance. Your institution is permitted to report the incident and disclose the footage to the police, but you should only disclose the information that appears to be relevant and necessary for the potential investigation. In all cases, you should make a careful assessment of the circumstances before deciding whether to disclose personal information to a law enforcement agency. When permitted under the law, it is important that you disclose personal information in a manner that protects the privacy and security of that information. If you do not already have them in place, develop policies to ensure that any disclosure of video complies with your lawful disclosure responsibilities. A good practice is to maintain a log of each disclosure that includes the date, time, and location of the footage, as well as the reason for the disclosure. Ontario's access and privacy laws also set out rules for the minimum length of time institutions must retain personal information. In general, you are required to retain personal information for at least 1 year after you have used it to give individuals to whom the information relates an opportunity to access it. Note that this retention requirement only applies to personal information that you have used. It does not apply to personal information that you have collected but not used. Personal information is considered to be used whenever it is accessed or disclosed. Simply viewing a live feed does not count as a use. To this end, any video footage you have collected but never used should be routinely erased according to a standard schedule. We recommend that unused videos be deleted within hours or days of the recording. When deciding how long to keep unused video, consider the amount of time reasonably necessary to discover or report an incident that occurred in the space under surveillance. Your security obligations under the law require you to protect personal information under your control from unauthorized access, destruction, or damage. In the context of video surveillance, this means that you must ensure the confidentiality, integrity, and availability of the footage captured by your system. To help you do this, define, document, and put in place measures to protect your video surveillance footage. A few measures to consider include strongly encrypting video surveillance footage both at rest and when transmitted across open public networks, storing physical records of footage, such as disks, memory cards, or servers, in a locked facility, limiting staff and other people's access to footage to a need-to-know basis, storing monitors in a secured location where they are not visible to the public, regularly updating systems and applications to protect against vulnerabilities, and keeping auditable logs of all accesses, uses, and disclosures of footage that are generated automatically where records are maintained electronically. Fulfilling your security obligations requires collaboration. You may need to consult with the system provider and/or technical staff to implement some of these measures. Now that we've covered your video surveillance obligations under Ontario's access and privacy laws, let's turn our focus to 5 best practices that will help you protect people's privacy. Privacy Impact Assessment, or PIA, is a basic and essential tool that will help you identify, then mitigate, the potential privacy risks of a program you are developing, such as video surveillance. By conducting a PIA, you will be able to address issues such as the lawfulness of the collection, use, or disclosure of personal information. A PIA will also identify safeguards you could or must adopt to eliminate or reduce the risks. In turn, you can incorporate these safeguards into your institution's policies and procedures on video surveillance. It is important that you conduct a PIA before your institution begins using video surveillance. You should also review your PIA when you make significant changes to the program. Your institution should consult with individuals who would likely be the most affected by surveillance in a certain area. It would benefit your institution to find out about the need for video surveillance and the impact of its proposed use on the public. This consultation will provide people with an opportunity to comment on the specifics of the program, including the location of cameras and the use of video surveillance itself. Ontario's access and privacy laws require that you define, document, and establish measures to safeguard your video footage. You should also update your policies when you make significant changes to the program. For example, when you upgrade equipment. These policies may include details such as the rationale, objectives, and justification for implementing the program. You should also consider making these policies available to the public. You are responsible for training employees to ensure that they understand their duties with regard to your institution's video surveillance program. Educating your employees on their responsibilities is an essential step to achieving an effective program that complies with our access and privacy laws. We recommend employees attend an initial privacy orientation followed by regular training sessions. This training should include detailed information on your institution's policies and the obligations arising from them. Make sure you regularly audit the roles, responsibilities, and practices of your institution's video surveillance program. This will ensure that they are in line with your policies. Also, reevaluate the need for a video surveillance program regularly to determine whether it remains justified. It is important that you address any concerns identified in your audit in a timely fashion, in some cases immediately. Let employees know that their job activities may be subject to an audit, and inform them that they may be asked to justify particular instances where they accessed video footage. Finally, in the interest of transparency, consider making the findings of your audit available to the public, just as you would your policies. Video surveillance technologies continue to evolve, as do public expectations surrounding their use. The focus of this webinar has been on the various issues, requirements, and best practices for video surveillance. Other forms of surveillance, including automated license plate recognition, or ALPR, and body-worn cameras, raise additional privacy issues that require additional safeguards and controls. Please see our guidance on ALPR and body-worn cameras for more information about these surveillance technologies. Ontario's access and privacy laws strongly support the proposition that the public has an expectation that they will not be subject to extensive surveillance. Your institution must ensure that the public receives the benefits associated with video surveillance technologies while continuing to provide strong privacy protections owed to all citizens. A video surveillance program that protects individual privacy will help to mitigate privacy risks and help your institution meet its obligations under the law. Thank you for joining us today. We hope that you found this presentation helpful. Please see our video surveillance guidelines for more information on all topics discussed in this webinar. The IPC is committed to working with Ontario's public institutions, and we welcome you to contact us if you need additional guidance on video surveillance. And be sure to subscribe to our YouTube channel for all of our latest videos. Thank you very much.
Welcome back, everybody. This is Brian Beamish, and again, I'm joined by Assistant Commissioner David Goodis and Jennifer Rees-Jones, a Senior Policy Analyst, to answer your questions. We have received lots of really good questions during the 20 minutes of the video, and we'll try to get to as many as we can. I would start by saying that, as you've seen, the presentation dealt with in effect, stationary cameras and did not touch on issues like body-worn cameras for law enforcement or automated license plate readers. As the presentation indicated, we do have specific guidance on that, and I would refer you to our website to see those. So let's get to the questions. David, maybe I can ask you to start on this one. We had a lot of questions about granny cams in long-term care homes. And I take it these are cameras that a resident or the family of a resident of a home would want to put in the resident's room in order to monitor care or potential threats or danger to the resident. Do you want to touch on that particular policy and appropriateness?
Sure. So the way we would look at this is it would not be the facility that's collecting the images. So that means that our health privacy law would not apply to that kind of video collection of images. In terms of a best practice, though, we would say that cameras should only be installed certainly with the consent of the resident or in a situation where there is a substitute decision maker with that person's consent. Another thing to keep in mind if these kinds of cameras are installed is to think about the privacy of other residents and even visitors. The view of the camera should be limited to the one individual space and should not encroach beyond that person's personal area. We also think that in most cases audio should be disabled because you can imagine that if the audio is on and is capturing conversations, there is a risk of capturing personal information of others that's not necessary for the purpose of protecting the person's safety. The facility really should think about having a policy on the use of granny cams since they are something that's on a lot of people's minds to implement. So the policy, I suppose, in theory could be, we don't accept granny cams, they shouldn't be used at all. That might be difficult to defend. I think what's more likely acceptable would be the facility saying, we're aware that people want to use granny cams. They're permissible, but here are kind of the limitations on their use. They're okay if they're used in accordance with best practices, as I mentioned, but we will not accept the use of these cameras that is overly invasive and just not acceptable in terms of the best practices.
So really, we're talking about a situation that's unlike a hospital room. A residence in a long-term care home is that individual's residence, so they would have more rights than a hospital patient would have. What if there was a policy in place that said you could only use overt cameras and not covert cameras, but it was discovered that there was a covert camera? Would the facility be able to remove that camera if it violated their policy?
Yeah, I think in that situation where the facility said, look, we don't find covert cameras acceptable, because of the lack of fairness and transparency and kind of being sneaky and recording images, I guess you could say. I think it would be acceptable for the facility to say, that crosses the line. We don't want that type of video surveillance. We're okay with overt cameras. That's acceptable. But when you do cross that line, we're gonna remove those cameras. Although I think there could be some debate about the authority to actually remove the camera. But I think overall the facility should be able to control its space to a large extent. And if it has reasonable policies on the use of these kinds of cameras, they should be enforceable.
And just one last follow-up. We did have a question about a family concerned about common areas, violence in common areas involving their family member, and wanting to locate a camera in a hallway or a common area. That does not sound like a good idea.
Yeah, I think
that's the family wanting to do it themselves rather than the facility.
Right. I think that's a lot trickier because, of course, now you're getting into a space where there are all kinds of residents that are moving back and forth through that common space, and I think it's just much, much more difficult to justify, that kind of collection of video that goes obviously very far beyond, the one individual that you're concerned about. So, unlikely to be considered appropriate.
Great. I should say we had a lot of questions on this, and given the volume of interest, we'll be looking at putting out some specific guidance on this particular issue. So if you sent in questions on granny cams and we didn't get to them, stay tuned and hopefully we'll get some further guidance out. Jen, the presentation highlighted the importance of notice, and we had a couple of questions regarding notice. One was, are organizations mandated to post a notice on their website, and is there an obligation to notify neighbors about the cameras?
So the laws don't explicitly require that institutions post the notice on their website. What they do say is that individuals have to be informed of the legal authority for collection, the purpose for which the information is going to be used, and the contact details for someone so that they can answer questions about the collection. But we recognize that it's challenging to fit all of that information on a sign. So that's where the website would allow you to provide greater detail. What we would recommend is that a simple sign be displayed on the site with an image representing a video camera or something that clearly signals that video surveillance is being used in the area. And then all of the requirements set out in the Act can be made available on your website. Posting the notice on the website also helps to ensure transparency, and as a result will increase public trust and support of the initiative as well. The second part deals with the question around notifying neighbors of the video surveillance. I think this is another example where the signage will be really important because it will help make the neighbors aware of the presence of the video cameras. In this instance, it would also be a good practice to talk with any of the stakeholders or consult that may be affected by video surveillance. So in this instance, certainly the neighbors. And maybe one other point I'd reiterate is that the camera should certainly be set up in a way that only is going to capture the areas that have been identified as needing the surveillance, and so make sure that it's not, in this example, capturing the neighbor's property.
Great, thanks. We had a question that comes to us quite often, and that involves when are organizations and institutions able to proactively disclose information to the police based on their belief that a crime may have been committed. And this particular question that came in was from a hospital saying that they have cases of violence that occur in the hospital, and they do report them to the police, but are they able to proactively disclose video images of the incident to the police, or are they required to wait until they get a warrant from the police? I think the answer to that is that organizations under both our privacy laws, public sector and health sector, do have the discretion to disclose information to the police on their own initiative where they have a reasonable basis to believe that an offense has occurred on their premises. So they have video evidence of an incident. They do not need to wait till the police come with a warrant. They're able to proactively disclose that. But I think it's important that a couple of ideas are kept in mind. One is that the disclosure should only be what is relevant and necessary to aid a potential investigation. So rather than turn over a whole day's worth of video from a camera, it should be limited to what's relevant to the particular investigation. The other is that should the police come back and require additional information, you should then be deciding whether you can provide that information without a warrant or whether you're going to wait for a warrant. And that may depend on the volume of information the police want, how many people are involved with the information, and the sensitivity of the information. So in the case of the hospital setting that we have here, while the hospital may proactively turn over video showing a potential assault or alleged assault, if the police come back and want health files of people involved, that may be a situation where the hospital says this information is so sensitive, we're going to wait for and ask the police to come back with a warrant. As the presentation noted, the transfer of the evidence to the police should be done in a sensitive, secure manner. So that may mean encrypting video footage, and the institution should document that particular disclosure to the police and why they did it. I will finish by saying that, again, we get a lot of questions about this issue, and we will have a very specific guidance document coming out very shortly, hopefully in November, around disclosure of personal information to law enforcement. David, we've had a couple of questions, and this is an issue that we have been involved in the past regarding rules around video surveillance of private property. not cameras that are controlled by a public institution and on public property, but cameras that are controlled by private individuals on private property. Are there any rules around that?
Well, there are, but the starting point is that Ontario privacy laws are not going to apply where a person installs a camera, on their own property for their own purposes. And the common example is somebody putting in a security camera that's just aimed at their front door. As a matter of fact, I just installed one a few months ago on my front door, so I do have that. And in terms of best practice, I did actually talk to my neighbors about it and let them know that I have a camera there, but assured them that the camera is not pointing to their property. And that's really important, that the scope of the camera is limited, to your own property and not, capturing images from your neighbor's property or even images from public space like the sidewalk or the street, in front of the house. That's not where the law ends, though, because it's possible actually that a municipal bylaw could come into play here. And there are a few municipalities in Ontario that have bylaws that prohibit private individuals from installing video surveillance that captures images that go outside the perimeter, of their own property. A couple of examples: Hamilton, Burlington, and Milton. While there aren't many of these bylaws, I think they do kind of capture what we would say is an appropriate best practice in terms of limiting the scope of the video surveillance to your own property, so that we don't get into a situation where you walk down the street and all kinds of people's cameras on their private property are capturing you walking down the street, or capturing activity at the neighbor's property.
Great. Jen, we've had a few questions around technical features of CCTV cameras. We know that they can pan, tilt, and zoom. That functionality is on a lot of cameras now. Our question is, if you have a camera that has that functionality, can you move it? Can you manipulate the camera to get a better view if you see some suspected criminal behavior?
Yeah, I think that last part of the question is really the important point to focus on here. So the pan, tilt, and zoom functions on the camera should really be limited to circumstances where it can be justified. So as you said, where there may be concern about possible criminal activity, it really shouldn't be used beyond those purposes. As well, if the pan and zoom functionality is enabled, then you need to make sure that the video surveillance policies reinforce this thought that it's only to be used when the circumstances justify it.
Okay, and I guess the important thing to keep in mind is that functionality will increase the ability to capture very identifiable information as well, as compared to a stationary CCTV camera. That has to be kept in mind.
Yeah, this all goes to sort of the sensitivity and the amount of information that you can capture that increases. So that functionality really needs to be limited and justifiable. And
there seems to be a training issue here that the operators of those cameras have to be sensitive to the occasions when it's permissible for them to use that functionality. We've heard the anecdotal stories about board camera operators using the zoom functions in ways that most people would consider to be inappropriate.
Exactly. We don't want any snooping with these cameras.
Right. We had a question, a really good question around using screenshots or of individuals that are captured. And I think the scenario here is you may be an organization that has a public face. You have people who interact with the public on a regular basis. It may be a service counter, what have you. And there may be concerns around safety. You may have an individual who's overly aggressive, who has made threats to staff. What is the ability, if you have video surveillance, to take a screenshot of that particular individual and provide it to staff so that they can be aware that they should be on the lookout or sensitive to the fact if this person comes up to them? And I think the short answer to that is yes, that is permissible. It would be considered a use and disclosure of that personal information and therefore has to be justified under our privacy law. But if there is a reasonable basis to suspect that there is a potential for misconduct or criminality, or that staff's safety are threatened, then yes, it would be permissible to take a screenshot and share that with staff. Keep in mind, though, it should only be shared with staff that are required to see it, that have a need to know. So that means that it should be those people who may be under threat or feel threatened or need to be aware. That may be, again, your public-facing staff. It may be security, what have you. There may be no need to share it with your entire organization. And again, if you're doing that, just remember to make a record of the fact that you've done it and who you have disclosed it to and why you have done that. We had a question about CCTVs that capture an individual on your property, and then the individual approaches the company, your organization, and asks for a copy of that video before it's been overwritten. The question is, if the person puts in an FOI request for it, do they have a right to that, even though it does not fall within one of the intended uses of CCTV? So it's a case where it's an innocent person, presumably, who's on the property but wants a copy of it. I think, David, subject to what you would say, it strikes me that the individual has a right to that. It doesn't matter what the original purpose of the CCTV camera is. If their image is captured on the video and the video still exists, hasn't been overwritten, our access and privacy laws would give them a right to see it.
Yeah, absolutely. And I think you just go back to the basic notion that people under our laws have a right of access to their own personal information. So they are going to be entitled to access, of course, subject to any potential exemptions, and that that can get complicated when you get into video images, including both audio and video. But as a general rule, you're correct. The law is going to say that person is entitled to access to their own images.
Great. And if I could ask you another question related to law enforcement use. We've had a few questions about this. I spoke earlier about the ability to proactively, an institution to proactively disclose video evidence where they have a reasonable basis to believe a crime has been committed without a warrant. What about the case where the police come to the organization and say that they would like to have access to that to the video, and second follow-up to that is if that video shows other people involved, not just the alleged actor, is there a need to blur those images, or can the entire footage be turned over to the police?
Okay.
And when would you want a court order?
All right. Well, this one is tricky, and Brian, as you said, our guidance is going to simplify as best we can, how to navigate the privacy laws on this kind of situation, disclosing to law enforcement. But I'll take a shot at it. So, our starting point is that privacy should prevail in the sense that the general rule is organizations should only disclose personal information to police when required by law. So what does that mean? That usually means, required by law usually means there's a warrant or a court order that police produce. So in that case, you're required by law to disclose. So again, general rule, don't disclose unless there's a court order. However, it gets more complicated than that because our privacy laws do say that you can, in appropriate situations, disclose personal information to police without a court order. So how do we figure out when that's okay? Well, the first situation I'll mention is urgent circumstances. So there can be cases where the police approach you, say we need a copy of that video because there's an urgent situation where we're trying to resolve a matter where, a crime has been committed, or they're trying to apprehend a suspect, or they're trying to prevent somebody from being harmed. Sometimes we talk about, for example, a kidnapping, that kind of thing. where you would say, well, I'm going to disclose, as long as the urgency of the situation, is clear and convincing, then you're going to say, well, I'm not going to insist on a court order because of the time that could take, hours or days, so I am going to disclose. So that's one example of where you might disclose without a court order, but they're not going to be that common. I think what would be more common is a situation where they simply say, we would like to have access to this information, this video. We don't have a court order, but we still would like your cooperation and like you to disclose that information. So what the courts tell us is, well, first of all, what the law tells us is you can disclose video to aid a law enforcement investigation. So that's okay. But then the courts, in some of their decisions on this pretty sensitive issue, have said, well, you should only disclose without a court order where the disclosure is not likely to intrude on a reasonable expectation of privacy. So now how do we handle that? What is a reasonable expectation of privacy? So again, the courts give us some guidance on that, and they say, well, in order to assess whether there's an intrusion on a reasonable expectation of privacy, you should look at various factors. And the key factors really are the sensitivity of the information. And of course, we know that there's a range of sensitivity. Some information can be a lot more sensitive than others. Have the number of individuals involved. So is it one individual? Is it several? Is it hundreds perhaps? How many individuals are we talking about? And of course, the more individuals that are involved, the more sensitive it can be. And how many non-involved individuals are captured by the video as well. So these are factors that are going to help you determine whether it kind of crosses the line into being overly intrusive, and you should insist on a warrant or a court order, or not. It really it's very circumstantial. But in terms of a best practice, we would say, however you respond to the police when they request information like this, make sure that you document the decision that you made in a lot of detail, and that you explain the circumstances surrounding your decision.
Great. Just to reiterate, we will be having, hopefully in November, guidance coming out not only on proactive disclosure to the police, but what to do and how to respond when police come calling for information from you. So look forward to that. Jan, this is a sort of a follow-up question to what David was saying, and it is, can the organization itself go back and look at video if they, and review an incident if they think there was suspected behavior? And it seems to me that that's okay. That's why you have the videos, one of the reasons you have the cameras there in the first place.
Yeah, that's right. This one's pretty straightforward. Certainly you can play back the footage if you think that there might be criminal activity. You should also retain the video footage and log the access. So logging it would include things like what footage was accessed, by who, when, and for what reasons. Great.
We've had a couple of questions dealing with the location of video surveillance cameras and where they can and cannot be placed. One of the questions related to locating cameras in a swimming pool area and whether that's appropriate or not. And even restricting the access to any images to senior management and making sure that there's no remote use of that or access to it. I think as the individual who sent this in understands, you're talking about some sensitive issues here. Normally people go to the pool, they're probably not expecting to be under video surveillance. You'll also have young people there in their bathing suits. I think you'd really have to look long and hard at whether there's a justification for putting video surveillance cameras in that type of situation. The issue of vandalism was raised, and I suppose you could consider deploying cameras that only operated after hours when vandalism is likely to occur. Although I'm sure we'll have people asking, they'll notice the cameras or your signage, you are going to have to field questions and concerns that you are videotaping people in bathing suits and young children in bathing suits. So I think you'd want to think long and hard before you went down that road. The other had to do with cameras that are designed to address vandalism in a public park, and the idea of having a live feed on that camera so that people could view it online. I think in terms of, is it justified to put a camera in a public park to combat vandalism? You'd have to look at the guidelines on deployment. Is it justified? Or is there a serious threat of vandalism, or have you experienced vandalism? So you'd have to satisfy yourself it's justified. As to a live feed that people can view online, my sense on that is if people can view identifiable individuals online, that is not a good idea, and I would definitely stay away from it. I think most live feeds that we see and that are acceptable are ones that take a broad overview of an area, and it's very difficult to identify any individual. One that would be placed so that people could be viewed, identified online, I think is a bad idea, and I would definitely stay away from that. David, if I could ask you a question about the personal devices. And when the question that we got was, when does it become illegal to take a photo or video of someone with a personal cell phone? And are there ways that people's privacy and rights are being breached when that happens?
Yeah, so the way we would approach this is to say, is the device or the phone being used in a personal capacity, or is it being used in a professional or official capacity? So we'll start with the personal. If you're capturing images on your own phone in your personal capacity and it has nothing to do with performing your job duties, then our privacy laws don't apply strictly. However, you could be in a situation where you would be in breach of civil law. So if you're using your personal cell phone to record people, where they have a reasonable expectation of privacy, perhaps in a locker room or inside their home or something like that, then you could run afoul of the tort of intrusion on seclusion, which is a civil law concept. So somebody could sue you for invading their privacy and seek damages for that. The other thing that you need to think about when using your personal cell phone to record people is the Criminal Code offense of voyeurism. So some of the situations I just mentioned could cross the line in terms of being voyeurism under the Criminal Code, and there's actually a big case on that right now before the Supreme Court of Canada called Jarvis, which is exploring kind of the limitations on the Criminal Code offense of voyeurism, where somebody did use their personal device to record a teacher who recorded students. If we're in a situation where somebody's using their personal cell phone in the course of their duties, and that can happen, where they say, well, I'm using it, to perform my job because I wanted to capture a certain incident or situation, well, then maybe privacy laws, or probably privacy laws, would apply. But this is an area where we think that the organization should have a policy on this and say, I really think the best practice would be to say employees should not use their personal cell phones to take video or photos in the course of their job duties. So really kind of I guess you could say a ban against using personal phones for that purpose. Sure, there may be situations where it's actually reasonable for somebody to do so. Say, a serious incident where somebody says, I really must capture this on my phone because this is something, that's highly serious and needs to be recorded. That would probably be acceptable, on an exceptional basis. But in general, it's really not something that should be a routine practice.
Great, thanks for that. We have had a lot of questions around video surveillance in hospital settings. And this is probably one that we could do a full hour webinar on. But let me just touch on a couple of issues that have been raised by the questions we've had. And I think the questions distinguish between two types of uses. One is, I guess, what I would call general surveillance of common areas, the foyer of a hospital, the doors at the entrance, the type of cameras that are located in a lot of institutions. And I think our view on that is that those types of public areas of a hospital, the reasons why a hospital would locate cameras there are similar to the reasons why any organization would locate cameras there, and the same kind of considerations that we see in FIPA should be applied. In other words, is it justified that those areas are high traffic areas, that those areas be locations for cameras? We've had a lot of questions though about locating cameras not in what you would call the public high traffic areas, but in specific settings like emergency and mental health. And my view is that those would be allowable, but there certainly would be a higher threshold that you would have to look at before you started to locate cameras there. Understanding that an emergency ward of a hospital is going to be a place where there may be incidents that where video surveillance cameras would be helpful, similar to a mental health facility. So there should be extra caution exercised before cameras are located in those areas. A few questions have come in about if we have cameras there, do we have an obligation to provide individuals with access to the images that are captured? And I think the answer to that, and this could also come up in say the mental health setting where you're videotaping an individual's therapy sessions. My view is that yes, the individual would have a right of access to those, subject to the kinds of exemptions that are found in PHIPA. So unless one of those exemptions apply, an individual would have a right of access. A related question to that is the issue of responding to an FOI request and blurring images and how do you, if you get a request for an FOI request for video that has the requester's image but other people's images, how do you respond to that? David, do you have some views on that?
Yes, we actually have had to grapple with this on a number of occasions. Usually it's not that simple where the person says, "Oh, I want the video of me," and there's only that single individual in the video. That's the easy situation. Of course, often the person requesting their image is in the video along with other people. If those other people consent, no real issue. But normally that's not the case. So the institution then has to say, well, we can only grant you access to your image, not others. So how do you deal with that? Thankfully, there are actually services and there's software available that's able to blur out the faces of the other individuals or the images of the other individuals so that that video can be prepared for disclosure, can be disclosed to the requesting individual, and there's no invasion of privacy of the others. Where it can get complicated and contentious is where the institution says, well, this is going to be very expensive to do this blurring, and we're going to charge you a fee for that. The fee might be very high, and the requester may balk at that, of course. So you may be into some back and forth on that. There are ways to, as an institution, to manage the cost, and the requester should also be cooperative in going back and forth on this. So perhaps the requester says, well, I want the full hour of video, but it turns out they're only looking for, say, an essential few minutes of the video, so you can curtail the cost that way, so that the blurring only has to happen, on a much more limited amount of footage. Or another option that we've seen is people saying, well, I'll take stills instead, which are going to be less expensive to produce and to blur, and maybe that will satisfy the requester.
Yeah, and I understand this is not an uncommon issue to come to us where people have filed an appeal after they've put in a request for images, and that we have had, as you mentioned, we have had success in mediating this by looking for cheaper. It's normally an issue of cost and looking for a cheaper option.
Right.
Okay, I'm sorry we didn't get to a lot of questions. We really did receive some really great questions. I mentioned that we will be going over those and looking to put out an FAQ based on the types of questions that we've received. Thank you very much for sending those questions in, and thank you to David and Jen for giving me a hand on the webinar today. And I do want to thank everyone there for joining us today. This is something that we look forward to doing and providing as much guidance as we can to organizations that are interested in meeting their privacy and access obligations. That brings us to the end of the webinar. Thank you, and goodbye, everyone.